Sorry, yeah, I'm supposed to use the mic. Test. Yes. Hold on, I'm supposed to use the mic.
Why? Why?
Okay, yeah, sorry for the disturbance. Okay, so like I said, the first part is the right an easement, right? Is it capable of being an easement? Just because a particular right on the face of it looks like an easement, it does not always mean that it is an easement. So you cannot just assume that, the typical easements, right? The right to park, the right to storage, the right to walk across the land, the right of way. You cannot assume that the moment you see a right of way, it's an easement. No, it needs to satisfy the requirements of Ellenborough Park. Because if not, it's just a license. Right? It's merely permission to walk across my land. That's different from it being an easement. Right? So in order to determine that, we went through the essential characteristics in Ellenborough Park, right? Very quickly, there must be a dominant land, there must be a servient land. Then there must be different people owning or occupying the dominant land and the servient land. There must be different people owning or at least occupying. It is or, it is not and. So diversity of ownership or occupation. Then thirdly, there must, the right, the easement that you are claiming, the easement must benefit the dominant tenement. It must accommodate the dominant tenement. And then lastly, the right must be capable of being an easement. So these are the headlines, of course. The details and all we've already gone through last week. So at this point, ladies and gentlemen, in your answer, you would have, or in your study of the subject, of the topic, at this point, what you will say is, okay, that particular right is capable of being an easement, right? That particular right is capable of being an easement. Okay, very good. But that alone is not the answer to your question. In your exam question, the person who you are advising, he doesn't want to know whether that right is an easement. He wants to know whether he can get that easement, right? So that's the second half of the question. The second half of the question is the acquisition. So you've already determined that that is an easement. Then does that easement belong to whoever you are advising, right? So if it was created expressly, very good, very easy, right? Express creation, we will look at it later. There's another table underneath this table. We will go through it again. But the focus of the chapter is always on implied creation, right? Implied creation. So when we look at implied creation, there are two ways of implying, right? Or two types of implying an easement. You got an implied grant or an implied reservation, right? Implied grant or implied reservation. I mean, if you think about it itself, I mean, you'd be able to understand what it is, right? So an implied grant is you are going to court and you're asking the court to imply that your neighbor has given you the easement. You are asking for the court to imply that your neighbor or whoever has given you the easement. Implied grant, right? Then there's implied reservation, right? Implied reservation is where you are going to court and you're asking the court to imply that you have reserved a right on your neighbor's land that you just sold off. So a good way to determine whether it's a grant situation or a reservation situation is if the person who is asking for the right is asking for it on land that he has just sold. If the person who is asking for the right is asking for it on land that he has just leased. So just being an important factor here, if I sold the land to you 10 years ago, now I want for an easement, that's no longer reservation. So just means you just sold it, right? Maybe 6 months ago, 2-3 months ago, whatever, right? So you've just sold the land, and now you want that easement on the land that you have just sold or leased. That is reservation. Other than that, it's all grant. That's a quick way to remember it. Other than that, it's all grant. Also, another tip to remember is look at who is asking for the easement. Is it the new guy that has come into the story? So they'll tell you originally there was Mr. A. Mr. A was owning both pieces of land. Then the new guy comes. Mr. A sold one of the land to Mr. B. Mr. B is the new guy in the story, right? The new guy in the story, if he comes in, for him, it's always going to be implied grant, right? It's always going to be implied grant, right? So you need to be able to determine whether the situation that you are looking at is implied grant or implied reservation. The reason is, if it is an implied reservation situation, you only have two methods of implying: necessity, common intention. Necessity, common intention, or some textbooks may say intended easements, same thing, right? If it is a grant situation, then there are four methods. If it is a grant situation, then there are four methods: necessity, common intention, the rule in Weldon against Burrows, and section 62. So yesterday, ladies and gentlemen, we finished, and also something to remember, the necessity for grant is the same as the necessity for reservation. The common intention for grant is the same as it as for reservation. The cases are different. So it's good if you can remember this is a necessity grant case and this is a necessity reservation case. Same thing with common intention. But the principle, the concept is the same. Right? The concept is the same. So we've already done necessity, we've already done common intention. Then we also went through the rule in Weldon against Burrows, right? But I promise you I will do it again. So I will do it very quickly again, right? A bit of a recap, right? And then we will go to section 62, right? We'll do the rule in Weldon against Burrows, and then we'll go to section 62. Like I told you yesterday, the rule in Weldon against Burrows and section 62, very, very, very likely to be tested. In fact, there's nothing else to test you on, right? For sure, it's going to be a 62 issue. There's going to be a Weldon against Burrows issue. So a very typical question will be 3 rights. Now again, this is a typical question. Doesn't mean it has to come out this way, right? But usually there will be 3 different rights. One of it will be a reservation issue. The other one will be a 62 issue. The other one will be a Weldon issue. Again, usually, right? It does not have to follow that way, right? But we'll look at some questions later. Okay, so let's look at the rule in Weldon against Burrows again. So what is the rule in Weldon against Burrows, right? So the trick here, ladies and gentlemen, is to be very comfortable with all the methods of implying the easement. Be very comfortable with all the methods of implying the easement. Why? Because when you look at the exam question, as you're reading the question, you must be in a position where you can already say, this is going to be 62, this one is Weldon, this one is reservation, or reservation necessity, or reservation whatever. You must be able to do that, right? You cannot be there sitting down and figuring it out. Right? It doesn't work that way. It's not something that you do some math, you do some calculations and you figure it out whether it's a 62 situation and whether it's a Weldon situation. It doesn't work that way, right? So as soon as you look at the question, the way the story goes, you will be able to figure it out. Like I said, you haven't really learned it yet. But once you learn it, as the moment you see, oh, okay, originally both pieces of land were owned by the same person. And the guy was using the easement on his own land. Already that is what we call a quasi-easement. Then immediately your brain must tell you, this is likely to be the Weldon against Burrows. Then he sells the dominant land. Remember, these are all the requirements, huh? Right now. Let's revise Weldon again. So firstly, he must sell the dominant part. Right? The vendor sells the dominant part of the land. Right? So the dominant part of the land, again, that is something to determine also on the facts. So Mr. A originally owned both pieces of land. Okay, I'm just giving you the same story. Huh? He stayed here and his garage used to be here. So he used to park his car here. Right? Then now A has sold this land. No, A has sold this land to B. Right? A has sold this land to B, the first one. Okay? Now, B wants to continue parking his car in the garage on A's land. Okay? So, look at the rule. Firstly, the vendor sells part of his land, the dominant tenement. You see, within these two lands, this is the dominant tenement and this is the servient tenement. Would you agree? Remember, how do I determine that? The land on which the right is exercised, that's the servient land always. And then the other land is the dominant land. Right? So when the guy sells the dominant land, right? Sell or lease, sell or lease. Okay? Then all quasi-easements. So this is important. All quasi-easements. So we spoke about this yesterday. What is a quasi-easement? Right? The word quasi means you are almost. No, that thing is. I can't put a figure value. I don't want to say 3/4 or whatever, right? But it's almost that quasi. It's not quite a full thing, but it's almost that quasi-easement, right? So a quasi-easement is effectively in the first part of your answer. It satisfies all the requirements of an easement. The 4 requirements of Re-Ellenborough Park, it satisfies it. But at the time when A owned both pieces of land, it just didn't have diversity of ownership or occupation. That, ladies and gentlemen, is what we call a quasi-easement. So, firstly, determine that there must be a quasi-easement there, and the quasi-easement was used by the vendor. All right? The quasi-easement was used by the vendor. That's important also. Because the new guy, Mr. B coming onto the land, he cannot just want to do something on A's land, his neighbor's land, that is just out of the blue. The courts are not going to do that. If now suddenly B goes to court and he says, I want to walk across A's land. I just want it. Cannot. It doesn't work that way, right? The law is not going to force A to allow B to walk across his land, right? Or A says, I just want to swim in his swimming pool. Cannot, right? It won't work that way. The only reason this works or this principle is here is because the idea is this: if the previous person was doing it, then it seems fair to allow the next person to do it also. Now, some of you might be thinking, well, that really is not fair. Right? I am selling it to a new person. Why should I allow the new person to do it? So if you believe that way, you're right. You're right. So don't worry. We are going to come to this. See, the rule can be excluded. The rule can be excluded. The law is not that silly, no. The law is not so ridiculous that it will force you to have your neighbor park his car in your garage. if you don't want that to happen, then when you sold the land to B, if you are A, when you sold the land to B, in the sale and purchase agreement, you will say, the rule in Weldon and Burrows will not apply to this transaction. Done. You don't even have to say, oh, B will not be able to park his car. No, the rule in Weldon and Burrows will not apply. Full stop. So that's why, ladies and gentlemen, you will find that there are not too many cases on these areas, because any sale and purchase agreement that is professionally drafted by a lawyer will have this clause. So in truth, in reality, you see, most people, when you buy property, you're not going to draft the contract yourself, isn't it? Really, it's just not worth it, right? You're not going to sit down and draft the contract, the sale and purchase agreement, and then the loan agreement. You're not going to draft the contract yourself. You can, but chances are you're going to mess it up. No? So what will you do? You'll go to a lawyer. The lawyer will have a standard template agreement already, right? All the usual clauses will be there. And so one of it will be, Weldon and Burrows will not apply. Section 62 will not apply. Generally, that's the case, right? You know where the only people that don't follow this rule are all the people in your University of London exam question. They will not follow this rule, right? But in real life, usually, if you buy property, you're going to get a lawyer to do it. All this won't happen. Are we okay? Okay, anyway, come back to this, right? So, when the vendor sells part of his land to the dominant tenement, all quasi-easements, so you got to determine that were previously used by the vendor will now become full easements in favor of the purchaser, right? In favor of the purchaser. So that's B. Now, then, that's not done, right? You need to also provide it. So there is a proviso. The proviso here is the number 4. You must satisfy the proviso. So what does the proviso say? Number 1, the right must be continuous and apparent, right? So we spoke about this yesterday. Continuous and apparent. So you see, we already see here, it must have been previously used, correct? It must have been previously used. But ladies and gentlemen, if it was used just once in the entire 20 years that Mr. A, so I'm still talking about that same example, if it was just used once in the entire 20 years that Mr. A was sitting there, the rule won't apply. It must be something that Mr. A did continuously, regularly. Now, the issue is, what does it mean by continuous? That's a matter to be discussed on a case-by-case basis. It doesn't need to be every day. It doesn't need to be every week. It just needs to be regularly. So it depends on it depends on the right? If, let's say, Mr. A used it only, like I said, I gave you an example yesterday, right? Mr. A used it maybe once a year, but every year, 3 months, he will use it. But every year he does it. That's enough. Even though it's just 3 months a year, then the other 9 months it's not used, but every year he uses it, that's enough. Right? So continuous is a matter to be discussed on a case-by-case basis, right? And then apparent. Apparent just means that the right cannot have been done in hiding. It must be done in the open, right? It cannot be done in a secret manner or whatever, right? Now, usually I get this question, what if it's the easement of underground piping? Underground piping, I cannot see, right? Now, if you read the case of Donovan against Rana, right? Underground piping, yes, you cannot see underground piping, but you can see the effect of the underground piping, isn't it? When you turn on the tap in your house, water comes out, that's because of the underground piping. It's obvious. You understand? When you flush your toilets, stuff goes somewhere, isn't it? It's because of the underground piping, right? So just because something is underground, it doesn't mean that it is not apparent. So apparent here is like, let's say, for example, this is a ridiculous example. For some reason, Mr. A only parked his car in the garage after everyone has gone to sleep from 2 a.m. to 4 a.m. secretly. Don't ask me why. That would be not apparent. That would be not clear. and that won't apply. The rule in Weldon and Burrows will not apply, right? So the rule needs, the right needs to be continuous and apparent. And so why have I put the word and there in capital letters? The reason is because until very recently, ladies and gentlemen, it was or. In 2015, there was a case that has come and confirmed that it is continuous and apparent and necessary for the reasonable enjoyment of the land, right? Continuous and apparent and necessary for the reasonable enjoyment of the land. The name of the case is, where is it? Wood against Waddington, right? Wood against Waddington. 1 and 2 must be satisfied. 1 and 2 must be satisfied. Okay? So what's number 2? Number 2, again, very easily satisfied. The right must have been necessary for the reasonable enjoyment of the land. Now, don't confuse this with necessity that we studied earlier, right? This one is literally, it just means that is it necessary for the reasonable enjoyment of the land? Does this right make it nicer to use the land? Does this right make it more enjoyable to use the land? That's all. The level is very, very low. Easily satisfied. But ladies and gentlemen, now that we know, the case of Wood against Waddington clearly tells us that both must be satisfied. So why am I highlighting that? If you are maybe reading some older notes or you've picked up a textbook that is maybe pre-2015, which you shouldn't, huh? But in case you're reading some notes that you inherited from a senior or whatever, pre-2015, you may see some of the notes saying or number 1 or number 2. Either one is enough. Today cannot, huh? Today it's and. The law for that is Wood against Waddington. Okay? Okay, so let's look at some of these principles. We already saw this. Huh? The rule can be expressly excluded, right? So that's important. The rule can be expressly excluded. So again, for those of you, and I saw some of you, when I said it, some of you were nodding your head, huh? Like you are thinking, how can the law force me to allow my neighbor to park his car in my garage? It doesn't seem fair, right? Well, you're right. So that is why this rule can be expressly excluded. If you exclude the rule, but it must be expressly done in your sale and purchase agreement or separately, right? If it is expressly excluded, then that's it. The rule in Weldon and Burrows will not apply. No, in whatever circumstances, the rule will not apply. So that's why when you do the answers, you will see that one of the first things you will start off with here on the facts, if it was not expressly excluded, it seems like the rule in Weldon and Burrows can apply. You know, you will use language like that. Okay? Right? Then only rights that are capable of being easements will be implied in this way. So, I mean, this is logic. It goes without saying, right? The rule in Weldon and Burrows is not some magical rule that can make a right that is not meant to be an easement or cannot be an easement and make it into an easement. It doesn't work that way, right? It must already be capable of being an easement. It must already be capable of being an easement. Now, this is where a lot of people will ask this question. So let me just address it now itself. So the timeline, let's say, is here, right? And then this is the sale. Again, I'm referring to this story here, right? Originally, A owned both pieces of land, and then there was a sale here, right? And then this is the dispute. So when I say dispute, means Mr. B has gone to court, right? So this is the timeline. Let's say, for example, right? Okay. At this point, there is diversity of ownership or occupation, correct? And when you are determining whether the right is capable of being an easement, When you are determining whether the right is capable of being an easement, that means applying the Re-Ellenborough rules, you are applying it at the point of dispute. I repeat, when you are discussing whether a right is capable of being an easement, which means applying the Re-Ellenborough rules, you are discussing it at the point of dispute, not earlier, not here. Right? So I'm sure these thoughts would have crossed your mind. Daniel, you are telling me that the rule will only apply for rights that are capable of being an easement, right? But at the point earlier, it was not capable of being an easement, because at this point, there was no diversity of ownership, correct? Before the sale, A owned the first land and A owned the second land. There is no diversity of ownership. There is no diversity of occupation. It doesn't matter, because the Re-Ellenborough rules are to be applied here at the point of dispute. You understand what I mean? Right? At the point that you are claiming for the easement, is there diversity of ownership or not? Is there a dominant land and a servient land? Is the right capable of, does it accommodate the dominant tenement? Is it capable of being an easement? All that is a discussion at the point of dispute. Okay? Okay. Anyway, the reason why I'm explaining that is because whenever we see this issue here, right, a lot of students sometimes ask, how can, if that is correct, if that line is correct, let's read the line again. Only rights that are capable of being easements will be implied in this way, but originally it was not capable of being an easement. Originally it was, there's no diversity, isn't it? But that's not where you look at it. You look at it at the point of dispute. Okay? Okay. Yeah, so coming back to what we were looking at, only rights that are capable of being an easement. So if, let's say, the right, was that it doesn't benefit the dominant land or is not capable of being an easement, then the rule in Weldon and Burrows is not going to make it into an easement. There's nothing you can do about it. Okay? The right must have been used prior to the sale. Okay, we already know that. Must have been used by the vendor himself. So this is also important. It must have been used by the vendor or his agents. So what do I mean by that? So let's say the person, Mr. A never parked his car in the garage. But Mr. A's guests sometimes will come and park their car in the garage. Then this cannot be an easement. I mean, it will not transfer to B. The easement must have been something that was used by A. Right? So when I say A or A's alter ego, that means if it is like A's family, right? A's wife parking their car in the garage, or A's children parking the car in the garage, that'll be okay. Right? But if A never used that right, so once in a while the examiner will also be able, will try and trick you on this. And I've seen one exam question. It was a shortcut. Right? It was the obvious shortcut. Let's say it was a shortcut across A's land, but A never used the shortcut. A never used the shortcut. A always used some other way. So when B bought the land, B wants to use the shortcut. Even though it is an obvious benefit to the land, it cannot. The only way in which Weldon and Burrows will apply is if A was using the land, the right. right? A must have been using the right, and A must have been using the right, like I said, continuously. If the last time he used it was 10 years ago, and then for the past 10 years he didn't use it, and then he sold the land, then cannot. Okay? And also, okay, 1 and 2, I already told you, Wood against Waddington, right? Lastly, it can also occur when both the dominant tenement and the servient tenement was sold at the same time. Now this is rare, right? But it has happened, right? This is actually quite rare, but it has happened. If A originally owned, so same story, A originally owned both pieces of land. He was parking his car, blah, blah, blah. A sold the dominant land to B. And then at the same time, A sold the servient land to C. A sold the dominant land to B. And at the same time, A sold the servient land to C. Let's say the rule in Weldon against Burrows can still apply. The rule in Weldon against Burrows can still apply, which means now B will get the right to walk over C's land. Now here, it just seems to you like even more unfair, right? C is like, he's got no clue. Suddenly he bought a land and now B can walk over his land. Again, the rule can be excluded. The rule can be excluded, right? But if you didn't exclude the rule, if you didn't, in your sale and purchase agreement, you didn't expressly exclude the rule, then yeah, this rule will apply. It will bind C. Are we okay, everyone? Okay. That is the rule in Weldon against Burrows. Let's now look at section 62. Right? Let's look at section 62. Do you have the statute? I tell you what, I want us to read section 62. So, just hold on. Okay. Now, even though everybody is sitting in front of me, I still have to do this, huh? Okay. Can we read section 62? Can you see that? This one. I just need you to read the first part here. A conveyance of land shall be deemed to include and shall, by virtue of this act, operate to convey. Okay? So now, immediately, we can see a few things that I want to highlight. I mean, you just take note of it. Of course, it's all in the notes anyway, right? But I want you to see the actual statute. So firstly, you see a conveyance of land. So that's an important thing. That is a very specific word that is used there, a conveyance. A conveyance means a sale or lease that is done using the proper formalities. A conveyance means a sale or lease that is done using the proper formalities. Ladies and gentlemen, earlier for Weldon against Burrows, there was no such requirement. For 62 here, you see clearly, for 62 to apply, the word that is used is conveyance. The definition of conveyance is a sale or lease that is done using the proper formalities. That means, in simpler language, it must be a legal sale. An equitable sale cannot. It must be a legal lease. An equitable lease, 62 will not apply. Are we okay? Okay. But that still doesn't tell us what is 62, right? Okay. So, a conveyance of land shall be deemed to include and shall. So, again, from your study of LSM, those of you that studied LSM, statutory interpretation. In legal statute language, shall means what? Must, right? Shall is not, when you're reading statute, right? When you're reading statute, shall is not the same as our normal English conversation, right? Shall in a statute is must, okay? So, a conveyance of land shall be deemed to include and shall, by virtue of this act, operate to convey with the land all of these things here. Now, we are not concerned with all of these other things. We are just concerned with this. But what does this essentially mean? 62 is what we call a word-saving provision. I repeat, a word-saving provision. It is a word-saving provision because now Parliament has put all of these things in the law already, so that you don't have to include it in every single contract that whenever you sell the land, you don't have to include it. Now, most lawyers will include it anyway. Why? I mean, it's impressive, isn't it? Right? You want to charge a lot of money, the more pages, it looks impressive. But if the lawyer is honest with you, a lot of things don't need to be put in that contract, right? Why? Because it's already in the law. So this means this clause, I mean, all these things here doesn't have to be in the contract, okay? So that's what a word-saving provision means, okay? But what does 62 mean? 62 means when I sell land to you, together with the sale, it must include everything on the land also. It must include all buildings, erections, fixtures, commons, hedges, ditches, fences, waterways, blah, 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 blah. See, this is to prevent people doing this. I show you this land. It's got a beautiful house. It's got a garden. It's got a nice fence. I say, do you want to buy it? You say, okay. You give me the money. And then what do I say? Haha, you just bought the land. You want the house? Extra. Now, that's silly, isn't it? That's ridiculous. You can't be like, oh, you just bought the land only. You want the house? Sorry, pay me more. Then you pay me more for the house. Then I say, oh, sorry, you don't get the fence. You want the fence? You pay like some budget airline travel like that, right? You want the fence? You pay more. See, they don't want a situation where people are conned that way. So, by law, when you buy land, now you are sitting there and thinking, oh, this one also the law must say. I thought it is assumed. You must never assume. The law now clearly says that when you buy land or when you sell land, it is automatically assumed and shall, that means it must include everything on the land. And one of the things that are on the land is easements. Right? One of the things on the land is easements. So essentially what 62 is saying, if we forget about all the other things, what 62 is saying is this. So if A is able to park his car in B's garage, let's just assume this is not an implied easement. B has officially, in writing, with the deed plus registration, B has given A an easement. Okay? Right? Let's assume that. B has given A an easement. Properly, expressly created everything. A can park his car in the garage. 62 says when A sells the land to C, that easement also passes to C. That's it. Right? When A sells the land to C, the easement also passes to C. C now can park his car there. Now, the literal meaning, the original meaning of section 62 is not controversial at all. It's just this. That's it. If you read 62(1) again, this is what it says. When you sell land together with the sale, now it cannot be any sale, it must be a conveyance. You must remember that. So when you sell the land together with the sale, everything, including any easements on the land, will pass on to the new owner. Okay? So that in itself is not extremely controversial. The problem with 62 is this. Right? So everybody understands 62 in its literal sense, in its original sense. It's quite clear, right? The problem with 62 is this. Well, I shouldn't say problem. 62 has been interpreted to mean this. And this is where your exam questions are going to come. Okay. A owns both pieces of land. A has leased this land to B. And A is a nice guy. A tells B, if you want, you can park your car in my garage. If you want, you can park your car in my garage. Okay? Now, this, ladies and gentlemen, at this point, is not an easement. It is a license. This is nothing serious, This is just two neighbors just saying, hey, you wanna park your car, just come park your car in my garage, right? Okay, now, then the lease ends, and then A renews the lease. A renews the lease. This renewal is done as a conveyance. Right? This renewal is done as a conveyance. So meaning it was renewed using the proper formalities. That means it's a legal lease. It's a legal lease. Okay? That conveyance, ladies and gentlemen, will convert that license into a full easement in favor of B. Right? Now, you are wondering, wait, 62 does not say that. Nowhere does 62 say that. But that's the problem, right? In the case of Hare versus Gilman and Inskip. Now, again, don't worry about all this. All this is in the notes. Hare versus Gilman and Inskip, and then earlier case of Goldberg against Edwards. Right? These cases have interpreted section 62. And you can see there, this is why I always want you to read the actual statute, so that you don't just accept. Because if I didn't show you the actual statute for you, you might think, oh, it must be that 62 says that. If you read 62, it doesn't say that. 62 says, if it's already an easement, you see, the word used is easement. If it's already an easement, if B had an easement, or and then when the land was sold or leased, then the new guy gets that easement. That makes sense. But it has also been interpreted by the cases. And remember, today it is no longer disputed. It is accepted as law already. Right? Maybe at the time of these cases, it would have been a debate. Today, it is no longer even a debate. It is accepted as tried law. So today, if 62 operates, 62 will also operate to convert a mere license into a full easement in favor of the person claiming. Now, obviously, that license must be an interest that is capable of being an easement. All that must have been discussed earlier already. That right must be capable of being an easement to begin with. But it's not an easement. It is only a license. I didn't give it to you in the proper formality or whatever. It was just permission. It was just oral. I told you, hey, just park your car. I'm a nice guy, right? The garage is empty. Why don't you park your car in my garage? Purely a license. Then I forget about it. Then I renew the lease. That renewal of the lease, by operation of the law, converts that license into an easement, a full legal easement that binds me. Does 62 say that? No. But the law says that. Right? The case law says, the case law has interpreted 62 to mean this. Are we okay? Okay, let's go back to the notes. And let's look at okay, let's read this. When a landowner conveys a legal estate in his land to a purchaser, right? So it must be a conveyance. The purchaser will be granted by automatic operation of 62 all rights that were previously enjoyed on the land. So this is what 62 actually says. So this also applies, obviously, right? This is what 62 actually says. But a very interesting byproduct of 62 is this. 62 will also convert into easements all those rights that were previously enjoyed but were merely licenses. Right? Precarious means a precarious right is an example of a license, right? So that were merely precarious, for example, licenses, right? For the benefit of the land that was sold. For the benefit of the land that was sold. Right? So let me give you another example. So I gave you one earlier. A, B. Both are owned by different people, right? A owns the land, B owns the land. So pretty much the same thing, right? Almost. But here the difference is this is not a lease situation. B owns this land, A owns this land. So B is allowed to store his things in the garage. B is allowed to put his things in the garage. This is not an easement. This is a license. Okay? This is not an easement. This is a license. B now sells his land to C. This license, ladies and gentlemen, will be converted into a full easement in favor of C. All right? The other example I gave you earlier. So this is one example. Another example. This is exactly the one I gave you earlier. All right, number 2. That's supposed to be number 2. Mr. A owns both pieces of land. He leases this land out to B, lease, right? And then, of course, B can come and park his car in the garage. Then the lease is renewed. Remember, it can work for sale or lease. The lease is renewed. So here it was the sale that triggered section 62. Here is the renewal of the lease that triggered 62, right? The renewal of the lease that triggered 62. That renewal of the lease will trigger 62. And so here it is not a case of B selling it to C. B is renewing the lease for himself. So now earlier, B only had a license. Now this license is no more. Today the license will be converted into a easement in favor of B. Okay? Now, as usual, in case you are all very concerned about this seems unfair, you're right. But you see here, the operation of section 62 can be excluded expressly. So, and also I said, most sale and purchase agreements, most lease agreements, if it is professionally drafted, if you have gotten proper advice, definitely 62 and Weldon will be excluded. Right? But if it is not, it will apply. Yes. As unfair as it is, it will apply. In the case of Newman against Jones, the judge applied the law this way, but the judge commented that this will discourage acts of kindness between landlord and tenant. Don't you think so? If you were the landlord and you now understand this law, you'd be a lot more careful, isn't it? You won't allow your tenant, your neighbor tenant, to just, walk across my land, park his car in my garage. I'll be very afraid, because if I forget and he's doing it regularly, then when I renew the lease, that license becomes a full easement. I cannot stop him parking his car in my garage anymore. I cannot stop him walking across my land anymore. Right? So yes, the operation of 62 can be excluded, but if you don't, it applies. Secondly, I emphasize this quite a lot. 62 applies only to sale and leases that are made by conveyance. That means, although I have put here must be done by deed, that is a very simplistic thing. The proper thing to say is must have been done using the proper formalities. So when you sell land, the proper formalities must have been followed. If not, means it won't, 62 won't apply. 62 only applies for a conveyance. When you lease out the land, it must have been the proper formalities must have been complied with. This one again goes without saying, but I'm saying it anyway. It's a, of course, only rights that are capable of being an easement will be created by 62. Right? So if that right to park, in the example, the right to park or the right to store, let's say it doesn't benefit the dominant tenement, or the degree of use is so great that the servient tenement owner no longer has reasonable use of his land. All those factors, if they are there, that means that right is not capable of being an easement. If it's not even capable of being an easement, you won't even discuss 62 or Weldon or necessity. You won't. Right? So please remember, guys, 62, Weldon, common intention, necessity and all work only if that right is capable of being an easement. That means it has satisfied the 4 requirements of Re-Edinburgh Park. If that in itself is not satisfied, you won't even reach this part of the discussion. Okay? And the use of the license that is to be converted into an easement must be done prior to the sale or lease. Okay. I mean, this again makes sense. So look at the 2 examples I've given you. Right? This first example, B is using the right. Right? B is parking his car in A's garage. Then he sells the land to C. That license must have been used prior to the sale. Right? Same thing with this example also. Originally, B leased the land first. So obviously, when he first leased the land, he wouldn't have done anything. So after he leased the land, then A told him, why don't you come and park your car in my garage? Then only he started parking the car in A's garage. So 62 cannot be used but with this lease, the original lease. 62 will apply for the second lease, because prior to the lease, it has already been used. And then the second lease comes about. This second lease will trigger 62, and this license will now become a full easement. Right? So the case of Campbell against Bank says that the use of that license must have been done prior to the sale. Okay? Then, next. If you are putting a star or whatever, this is important. There must be prior diversity of occupation. There must be prior diversity of occupation. Now, what does this mean? Prior diversity of occupation. Okay. This, ladies and gentlemen, is a good way for you to be able to distinguish whether it is going to be Weldon and Burrows or 62. For 62 to apply, prior to the sale or lease. Now, I'm going to call it the triggering transaction. Prior to the sale. So, prior to this sale, prior to this lease. Now, on these facts, there are actually two leases, correct? But this is the triggering lease. Right? So, prior to the triggering lease, prior to the triggering sale, there must be diversity of occupation at least. Here, prior to the sale, A occupied this land, B occupied this land. Satisfied. Here, prior to this lease, A occupied this land and B was occupying this land. So no problems. This is a requirement for 62 to apply. There must be prior diversity. Now, why do I say this is a good way for you to be able to distinguish when it's 62 and when it's Weldon? Because remember Weldon, what is the prerequisite for Weldon to apply? The prerequisite for Weldon to apply is prior to the sale or lease, there must not be diversity, isn't it? Now, I know that's not one of the criteria that is expressly said, but what is the criteria that is expressly said? Quasi-easement. Very good. How does something become a quasi-easement? When you are exercising the right on your own land, then it's a quasi-easement. So, ladies and gentlemen, all these are important little tips to remember as you're reading the question. Now, like I said, when we look at the questions, you will see what I mean about all of this. So when you're reading the question and you're seeing, okay, prior to the sale, the land was owned and occupied by the same person. It has to be Weldon and Burrows. If prior to the sale, now, the trick is sometimes there might be two leases in the same question. You see here, like this. This lease was in 2015, and then this lease was in 2020. So you must figure out which is the triggering transaction. That one I can't teach. It comes with experience. You must be able to see it, and then if you understand the law, you will know it, right? So this is the triggering transaction. Prior to it, different people are occupying the dominant land and the servient land. Then it cannot be Weldon and Burrows. It must be 62, or it could be 62. Right? Now, this, ladies and gentlemen, for a very long time, I used to teach students, this is the way in which you can sort of distinguish whether it's going to be a Weldon situation or a 62 situation. However, life cannot be that simple, right? Today, there is this case called Platt against Crouch. All right, take note of Platt against Crouch. Platt against Crouch has come and sort of mess things up a little bit, if you like. Right? Platt against Crouch today says, even for section 62. Now again, the general rule is for 62 to apply, there must be prior diversity. There must be prior diversity. But today, Platt against Crouch says that the prior diversity is not needed, even for 62. Prior diversity is not needed if the right is continuous and apparent. Prior diversity is not needed if the right is continuous and apparent. That means even in situations that traditionally would have been Weldon against Burrows, today 62 may apply. May apply. Provided the conditions are satisfied. Right? What is the condition? See, Platt against Crouch can apply. The prior diversity requirement need not apply, but the right that you are claiming must have been continuous and apparent. It must have been continuous and apparent. Now, does Platt and Crouch overrule these earlier cases, Long against Gowlett and Sovmots? The answer is no. Huh? Long against Gowlett, Sovmots against the Secretary of State for the Environment, these cases still stand. So the way you need to remember it is the general rule for 62. The general rule for 62 is there must be prior diversity of at least occupation. The general rule for 62, there must be prior diversity. Prior to what? Prior to the sale, prior to the lease. There must be diversity of at least occupation. But if the Platt against Crouch exception is satisfied, meaning if it is continuous and apparent, the right is continuous apparent, then 62 for 62 to apply, there need not be prior diversity. Okay? Ladies and gentlemen, that is section 62, right? So, look, I know it's a little bit tricky, right? But the more you do the questions, it will all fall into place. Trust me, right? Trust me on this. Yeah. So reservation we've already done, right? So reservation also has necessity and common intention, right? Okay. This is important. Huh? I need you to take note of this. So now we've spent the last few hours last week and today, yesterday and today, discussing how to imply an easement, correct? But then the important question is, when you imply the easement, what type of easement is it? So when I say what type of easement, my question is it a legal easement or is it an equitable easement? Because it still needs to exist as one of those two things. Right? So when you imply an easement, what type of easement is it? Is it a legal easement or is it an equitable easement? Now, ladies and gentlemen, the answer to that question is, do you remember in the beginning of the lecture, I drew out this timeline? Right? And then I said, somewhere here will be the sale or the lease. And then here is the dispute. The dispute is where the claimant is going to court and he's asking the judge, please imply the easement for me, correct? And how? I will show you that I deserve for the easement by way of necessity or by way of common intention. So that's my case, right? So I'm fighting it here. Okay? If I'm successful, what the courts are doing is they are implying the easement into this sale. They are implying the easement into the lease. Correct? Okay, then the nature of the easement that is implied will depend on the nature of the document that it is implied into. I repeat, the nature of the easement that is implied, that means whether that easement is legal or equitable, will depend on the document that it is implied into. So if the sale, that triggering sale, the sale that triggers 62, the sale that triggers Weldon and Burrows, the sale that triggers necessity or whatever, right? If that sale is done using all the proper formalities, or in other words, it's a legal sale, then the implied easement will be a legal easement. If the sale was done not using all the proper formalities, then the resulting easement will be a equitable easement. Fair? Simple enough? Right? So, conclusion. The nature of the implied easement whether that implied easement is legal or equitable depends on the document it is implied into. That's the simplest way of saying it. Right? Depends on the document it is implied into. Okay. If we are okay with that, we are pretty much done, but we need to do some revision from chapter 1. How to create and protect easements and overriding protection, all of that we need to remember. Every chapter you need to know this. For leases, how to do it. For freehold covenants, how to do it. For easements, how to do it, right? You need to remember, right? Now, if you remember this chart, this little table here is literally a cut and paste from the crash course on registration that I gave you. Right? So please remember that, that crash course on registration document that has it for all the interest, right? You cannot forget. Okay, so an easement, if it is expressly created and it's going to be legal, then it must be created by deed and there must also be registration. How do we know this? Section 27 of the LRA 2002. How to protect it? You don't have to protect it. Why? Because the very act of creation included registration, right? The creation process itself, the formalities of creation includes registration. So it's already protected. Is there any overriding protection? You all remember overriding protection, all that? I hope you do, huh? I hope you do. I'm going to assume that you do. Right? Overriding protection, even though I assume that you do, I'm still going to explain it again. Huh? Right? What is overriding protection? Remember, the law provides a list of rights where even if you didn't protect it like you are supposed to do, it will be given protection. Even if you didn't protect it like you were supposed to do, it will be given protection. Where is the overriding protection found? Schedule 1 and Schedule 3 of the LRA 2002. Right? Now, even if you don't remember, I'm just going to say it again, because the more you listen to it, the more you will remember it, right? Right? Even, I mean, look, might seem like a very childish way of studying, but honestly, for me, when I study, I talk to myself a lot, and I think it helps. The more I say it, the more I remember, right? So Schedule 1, Schedule 3. Schedule 1, Para 1, Schedule 3 and 1, Para 1, Para 2, Para 3. These are all the list of overriding protections. There are many more paras, remember, but for our syllabus, we only need to worry about 1, 2, and 3. 3 talks about easements. So we are not doing a revision on registration. This is just on easements. 3 talks about easements, Para 3. So Schedule 1, Para 3 or Schedule 3, Para 3 says that there is overriding protection for legal easements. Ladies and gentlemen, that is why this is important. Determining whether that implied easement of yours is a legal easement or an equitable easement is vital, because if it is a legal easement, there is overriding protection for it already. Under Schedule 3, Para 3. Now, I don't know if you remember, I'm going to remind you. When we studied registration, I would have asked you this question, right? What does it take to create a legal easement expressly? What does it take, or maybe I should rephrase it, how do you create a legal easement expressly? The answer is deed plus registration, right? So there must be registration, right? So if there's already registration, that means all legal easements must be on the title. If they must be on the title, they are already protected. So when we studied chapter 1, I would have asked you this question. If that is the case, then why does the law provide for overriding protection for legal easements? If the entire system today under the LRA 2002, the entire system in itself, which is a good thing, which is a smart thing, if you want to create a legal easement, it must be created by deed and there must be registration. If there's no registration, there's no legal easement, correct? That means, I know I'm repeating the same thing, but just let me do it. That means without registration, there is no legal easement. It cannot exist. Then why is there overriding protection for a legal easement? Remember, what is overriding protection? Overriding protection is where you should have registered it, but you didn't. The law gives you protection. At that time, you probably didn't see it. Today, you see it. There is easements are not just the legally expressly created easements. There can be impliedly created easements. So your schedule 1 or 3, para 3, protection of legal easements is actually for implied legal easements. Right? It's actually for implied legal easements, right? So, ladies and gentlemen, when you are doing your easements question, at the end, after you've determined it's an easement, after you've determined that the person that you're advising is able to get the easement, you must determine whether it's a legal easement or an equitable easement. Why? Because if it is a legal easement, it is given overriding protection. But let's say it's an equitable easement, ladies and gentlemen, there is no overriding protection. If it is an equitable easement, then the person who got the easement, he needs to run to the land office and enter a notice the normal way. Right? How do you protect an equitable easement? Enter a notice onto the register. If that is done, it will bind the third-party purchaser. Is there any overriding protection for an equitable easement? Is there any overriding protection? The answer is no. There is no specific overriding protection. We can consider para 2, paragraph 2. Can you remember what is paragraph 2? Paragraph 2 talks about an interest holder who is in actual occupation. So we can consider para 2. But the problem with para 2 is the case of Chowdhury against Yavu says that for easements, it's not going to be so easy. Right? For easements, it's not going to be so easy. Are we good? Okay, so that's the registration part. Now, this last bit here, ladies and gentlemen, seems like a lot. Don't worry too much. I'm going to summarize it for you. Abandoning an easement. Can you abandon an easement? If you have not used an easement for a long, long time, that easement is yours. That's not in doubt. The easement is yours. Properly, you have all the documentation, all that, the easement is yours, right? But you have not used the easement for a long time. So a long time is 10 years, 20 years. You've not used the easement at all. Is there the concept of abandonment? That means you have lost the easement. Long story short, read all of this, but long story short is no, right? You can not use your easement for however long. The law will still not say that you have abandoned it. You can, of course, you can expressly abandon your easement. You can sign a document that says, I am no longer using it. That's fine. But you do not, you are not deemed to have abandoned your easement purely by not using it. You understand what I mean? You are not deemed to have abandoned your easement. I repeat that. You are not deemed to have abandoned your easement purely because you didn't use it for a long time. See, this is a good example. The case of Ben against Hardinge, 1992. Here, an easement of a right of way that had not been used for, see, I was talking about 10 years, 20 years. This is 175 years. For 175 years, it was not used. What did the court say? There is no presumption that the easement has been abandoned, even if it was not used for many, many years. And then again, more recently in 2014, the Court of Appeal in Dwyer against City of Westminster, non-use of a passageway for 40 years did not constitute abandonment. Okay? Now, this abandonment issue is not a very common issue, but one naughty examiner may just slip it in here as a small issue here and there, right? So just remember, just because an easement has not been used for many, many, many years, and 175 years also, it does not mean that the easement has been abandoned. Okay. Done. Finish. Chapter finish. Are we good? Any questions? Any questions? Okay, so usually I'll give the break at 8:30, right? But since we are stopped to finish the chapter, we'll take a break now. Let's take a 10-minute break. We come back, and then we're going to start on questions. Those of you that perhaps don't want a break, then you can sit down and read this. Yeah. Okay. Let's take a short break. some time ago, but we will do more recent questions also. Tomorrow will be 3 hours of nothing but questions, right? So if we run out of the questions that I have answers for, I also will bring out just some questions from past year series, and we will just do it without an answer. Sometimes I think the when we do it without an answer, it's actually better. Right? When we have the answer, you always fall back on the answer as the safety net. Okay, let's read the question. Let's try and understand the question. I am going to assume that the question has already been read, so I'll read it one time with you. Dan leases Ralph a cottage which forms part of Dan's large country estate. Okay. Now, I always find it useful to draw out the story, but that's a matter of personal interest. Not everybody likes to draw it out and all that. Up to you, right? But I find it useful, right? Dan leases Ralph a cottage which forms part of Dan's large country estate. So Dan owns this. So let's assume that there is a cottage here. And then there is the cottage has a small garden. Okay. Let's do this as the garden. The cottage has a small garden and is a short distance from a main road. Okay, so let's say the main road is here. Now, your picture may look a little bit different from mine. That's fine, huh? As long as it satisfies what this question is saying, right? There is a track that runs from the cottage across a narrow strip of land belonging to Dan's estate to the main road. Okay, so shall we say this? This is the track. So let's label that as track. There is a track that runs from the cottage across a narrow strip of land belonging to Dan's estate to the main road. So, okay, so I assume Dan stays here. Dan stays in this nice big house here. Okay. Dan regularly walks from his estate through the cottage garden to reach the track. So Dan regularly walks from his estate through the cottage garden to reach the track. Are we okay? The track is the fastest route. What do you think the examiner is trying to test you here? Well, it's your first question, so don't worry, right? But after you've done a few questions, by the time you reach the exam, as you read this, you will immediately know he's trying to fish a necessity discussion here. He's saying it's the fastest route. The fastest route means what? It's not the only route. By mere fact that he has used the word fastest shows that there are other routes, isn't it? That means it can't be a necessity. Right? The track is the fastest route by which Dan can reach the nearest train station. But then, interesting here, for Ralph, however, it is the only means for Ralph to get access to the main road. Now, this in itself is still ambiguous for me. It's the only means to reach the main road. Okay, fair. Is it the only means for him to get out of the cottage? So we are talking about Ralph, right? Remember, Ralph has taken control of the cottage, right? He's leasing the cottage. So the examiner says it's the only means for Ralph to get access to the main road. Okay, fair. But does that mean it's the only way for him to get out of the land, get out of his cottage? If it's just the only way to reach the main road, but there is another way that he can get out of his cottage, then he cannot use necessity, because if you read the question, eventually Ralph wants to use the track. The track is not on his land. The track is on Dan's land. Remember, Ralph's land is the cottage and the garden. So he will want to use the track. So the examiner here is fishing. He's trying to bait you to have a necessity discussion. Now, the first one with regards to Dan, it's not a necessity discussion because the examiner himself has said fastest. Fastest means there are other ways that are slower. Okay, fine. But the second one is he's being a bit dirty, the examiner here. He says the only way, but he doesn't say the only way to get out of the cottage. Because remember, when we studied necessity, the standard is extremely high. If there was any other way to get out of the cottage, the courts are not going to give it to you by way of necessity. Okay? So we don't know. We'll have to discuss. All right? Then that only means for Ralph to get access to the main road. Okay, fine. A few weeks after the lease is created, Dan allows Ralph to store his quad bike in a locked shed. Okay, so somewhere here there is a shed. A few weeks after the lease is created. So interesting. So for Ralph, ladies and gentlemen, you will notice that. Where's the pen? Oh, sorry. You will notice that there is a, this is for Ralph. There is a lease, and then there is permission to store bike, and then there is another lease. We just learned this. What is this? What is this likely to be? Section 62. Because see here, a few weeks after the lease is created, Dan allows. This is not creating an easement. Dan allows. This is a license. No. There's no mention of deed plus registration, nothing. It just allows. He allows Ralph to store his quad bike in a locked shed on Dan's land. Then when Ralph's lease expires, he buys, oh, sorry. So this is not a lease again. Sorry. This is my fault. This is sale. When Ralph's lease expires, he buys the registered freehold title from the cottage from Dan. So you have a lease, and then after that, there is a license here. Then after that, there is a sale. The issue is, will this sale trigger Section 62 to convert this license into a full-blown easement? Now, again, I know it's your first question, so don't worry about it. But the point I'm making is, after a few, when you read it itself, you will immediately know. This is probably going to be a 62. This is probably going to be a Weldon, so on and so forth, right? So let's read that again. When Ralph's lease expires, he buys the registered freehold title to the cottage from Dan. Ralph and Dan fall out after a quarrel about the politics of fox hunting, right? So obviously they are fighting. They are fighting. They are no longer friends. As a result, Dan tells Ralph that he must pay to use that part of the track. This one, right? He must pay to use the part of the track that lies on the narrow strip on his land. Dan also insists that Ralph remove the quad bike. By the way, what is a quad bike? The bike with 4 wheels. Have you seen those? Sometimes it's known as ATVs. Those big fellas with 4 wheels, right? Why do you think the examiner is saying quad bike instead of just saying bike? What's that? Degree of use. Very good. This is essentially a degree of use issue, isn't it? Right? See, he doesn't tell us how big the shed is. He doesn't tell us how big the quad bike is. But you see, if he had just said bike, A regular motorcycle is actually quite narrow, right? No way, if you put a motorcycle in a shed, you no longer have reasonable use of the shed. How small must the shed be? But quad bike, that's a bit different, right? So maybe the shed is very small. And those quad bikes can be quite big, huh? You know, those big wheels and four wheels and, you know, those things. So that's why he says quad bike. That it matters, huh? So obviously for the shed, there's going to be a degree of use discussion there. There's going to be a degree of use discussion, right? Okay. Then here, where are we? As a result, Dan tells Ralph that he must pay to use the part of the track that lies on the narrow strip of his land. Dan also insists that Ralph remove the quad bike from his shed. Then Ralph, in retaliation, because Dan is doing all of this, Ralph now says he's going to lock his garden so that Dan cannot walk across the garden. Okay, ladies and gentlemen, before we get into the answer, we're going to look at the answer. We're going to read the answer, right? But before that, how many rights are in dispute here? How many did you count? 3? Did you all get 3 also? I got 3. What are they? The track, the right to use the garden, and the shed. Agreed? The track, the 3 circles that I've done there, the track, the right to use the garden, and the shed. Okay, now next question. Who is asking for which right? What right is Dan asking for? The right to walk across the garden, right? The cottage garden. And the other 2 is for Ralph? Yeah, right? The other 2 is for Ralph. Ralph is seeking to use the track. Ralph is also seeking for the right to park the ATV. I mean the quad bike. So this is an easement of parking, and then there's an easement of the right of way. Now, labeling this easement does not change anything. Huh? The law is not different for parking as it is to storage, as it is to underground piping. No, it's not. The law is exactly the same. But it's good to label the kind of easement that you have, right? So there's an easement of parking, there's an easement, and then the other 2 are rights of way. Right of way. Okay. Again, without looking at the answer, assuming that the re-Ellenborough requirements are all satisfied. Of course, in an answer, you don't assume, you discuss. But assuming they are all satisfied, what method of implying an easement do you think we are going to use for the shed? What does it seem like to you? Okay, let's start with the easy one first. Let's start with the garden. Dan is asking for the right to walk across the garden, the cottage garden. He owns the cottage garden, isn't it? Then he just leased off the cottage garden. And now he wants a right to continue walking on the cottage garden. What is that going to be? Reservation. Right or not? See, like that, huh? Like that. So first question we're doing, you just need a little bit of help. Fine. By the time you do the 3rd, 4th question, this will come to you very easily. Don't worry about it. Okay? What about the track? Now, this line I think is important. terrible. Dan regularly walks from his estate through the cottage garden to reach the track. That means before he sold the garden, when he owned the estate, he owned the cottage, he owned the garden, before he leased it, he used to use the track, isn't it? Every day he used to use, every time he used to use the track. Why? Because it is the fastest way to get to the train station. Again, a bit of logic here. Just like the Hong Kong society, the UK society, I think, is one that uses a lot of public transportation. I say this because the Malaysian society is not. We are very much so people who drive, right? Because we are lazy people, right? So, and it's interesting, because this shows the cultural differences and how sometimes it can affect the understanding of the question. Because obviously when the examiner wrote this, his intention is, in his mind, is the fastest way to use the train. For most people, using the train every day is normal. So that means Dan must have been using that way every day. The last time I used the train in Kuala Lumpur is years. Because number one, I'm lazy. But most Malaysians are like me, Right? So in my class, sometimes the students say, how do you know he used it regularly? Cultural differences, right? But you cannot later write to the examiner and say cultural differences made me not understand the question. You need to understand it. You understand what I mean, right? So the reason why I think, of course, the examiner didn't explain it, but in my opinion, the fact that he say it's the fastest way to the train station, the connotation there is it is used by Dan on a regular basis. Right? It is used by Dan on a regular basis. You need to pick up on those things. There was another question once. The examiner never once said that he used the pathway between the main house and the cottage. But what he said was, he used the cottage as an office. That's all he said. He used the cottage as an office. What is the connotation you will take from that? If that's an office, you must have been using that pathway regularly, isn't it? If not, means you don't call that place your office and then you don't go anytime, right? If that's your office, you probably will be going on a regular basis, which means you will walk on the pathway between the house and the office on a regular basis. The examiner may not come out and clearly and expressly say he used the path every day. But he will say things like this: it was the fastest way to the train station. He used the cottage as an office. So you connect the dots to show that it was used regularly, right? So Dan, when everything was his, Dan was using the track regularly, right? That means he used to go into the cottage garden and then from the cottage garden, go to the track. Now he has sold the cottage and the cottage garden. What do you think Ralph is going to claim to use the track? So in that particular scenario, which is the dominant land? Which is the servient land? For the track, the dominant land is the cottage and the cottage garden. The servient land is the rest of the land. This is another example. If you are looking for two boxes, A and B, don't have, right? That's when I teach that way. Sometimes exam questions won't come two boxes nicely side by side. It can, but it need not. Here, the dominant land is the cottage and the cottage garden. The rest of the land is the servient land. So the little strip of land at the bottom where the track is, that's the servient land. This one. This is the servient land here. This is the dominant land. This is the servient land. So when there was a sale or lease of the dominant land, it will transfer with it all quasi-easements. So when Dan was walking through the cottage garden to reach the track, that's a quasi-easement, isn't it? It will convert all quasi-easements that were used prior to the sale by the seller. That's why they told us it was the fastest way to the train. That was used by the seller prior to the sale. That quasi-easement will be converted into a full easement in favor of the buyer, which is Ralph. Provided it must be continuous and apparent, which I think it will satisfy, and necessary for the reasonable enjoyment of the land. Even for Ralph, the examiner said it is the only way to reach the main road, isn't it? It's necessary for the reasonable enjoyment of the land. So what have I just described? This is the rule in Weldon against Burrows. Okay, then lastly, the shed. The right to park in the shed. This is going to be 62. Why do I know 62? Well, again, it comes with experience, but the moment I see there was a lease and then the right was given. At that time, it was only a license. And then there was another lease or sale after that. When I see that pattern, I know it's going to be 62. Because that second sale or lease is going to be the transaction that triggers 62. So here, the license is going to be converted into a full easement in favor of Ralph. I told you yesterday, one right will be 62, one right will be Weldon, one will be reservation. Now, by no means it's a must, but it usually will be like that, right? Usually it will be like that. Okay, let's take a look at the answer. We'll go slow. It's the first question we're doing. I'm going to clear all of this. So the structure of your answer. Again, everybody can write however they want. You shouldn't be bound by any particular structure or whatever, right? But my advice, ladies and gentlemen, right? My advice is the re-Ellenborough discussion, do it together. Don't do it separately. Because there's a lot of overlapping discussion. Like there must be a dominant tenement and a servient tenement. It's a waste of time to repeat it 3 times. For the track, this is it. For the shed, this is it. For the garden, this is it, right? So for the re-Ellenborough requirements, my advice to you is discuss it all together. Put the 4 requirements. Only raise the issue when there is a particular issue, right? But ladies and gentlemen, when it comes to the acquisition, then you have to go about it either person by person or right by right. It has to be a separate discussion. It cannot be the same discussion, right? So for me, that's how I keep it systematic. I keep it clear, right? Subheadings for me are very important, but that's a matter of style. That's a matter of style, right? Up to you. You don't like subheadings, don't. But just make sure that your answer doesn't seem very all mixed up. Make life easy for the examiner, right? Don't make the examiner's life difficult. If he doesn't like your answer, he just... How do you know? He may take a look at your answer and, oh, this is terrible. I can't read it. I'll just give you a 45. Safe. You didn't fail, but you didn't do so well also. How would you know? You won't know, isn't it? Don't make life difficult for the examiner, right? Okay. Actually, things are a lot better ever since now it's typed out answers. Right? Last time when it was handwritten answers, is even worse. Have you all gotten information about how the exams are going to be conducted in Hong Kong? As in, more than it's going to be in a hall and invigilated. Other than that, have you gotten any information yet? No. But you all know, is it in a exam center? It is, huh? Okay. So it's the same in Malaysia also, right? It's the same in Malaysia. So if that is the case, it probably is going back to how the system was prior to COVID. So whoever was organizing the exams in Hong Kong prior to COVID And honestly, I don't know. Maybe you guys will know. Like for us in Malaysia is the Malaysian Examination Syndicate. The people that organize our school exams, the big exams and all that, they are the ones that will organize it, right? So they are probably going to be organizing it as well. But the logistics of it is ridiculous. Huh? I still don't know how it's going to be done. Because I think you guys in Hong Kong, based on the statistics that I got from the University of London, in the whole of Hong Kong, they are like maybe year one last year at 103 or 102 or something. Hong Kong numbers have dropped dramatically, right? In the whole of Hong Kong, year one, brand new students about 100. But in Malaysia, the whole of Malaysia, brand new students, year one, got about 400, maybe 500, around there. It's interesting how they're going to handle the logistics. Even 100 students. Is there going to be a hall big enough where you have a PowerPoint for every single one of you? Because you all are typing, right? Your laptops can't last full 4 hours, right? Well, I don't know if yours can, mine cannot. Right? So you will have to provide a place to plug in. And then the next issue is statute books. You all don't get statute books anymore, right? Oh, you haven't? I think you don't get statute books anymore. Everything is online now. So with the Inspera system, how are you going to refer to statute books? So, I mean, I'm saying all of this, not that I have an answer. These are genuine questions that we are also trying to figure out with the University of London. And sadly, the University of London also doesn't have all the answers straight away. I mean, if I want to be kind to them, I will say, it's their first time doing it and all. Let's all be kind to them. But at some point, I also at the back of my mind think, why should we be kind to them? They're organizing the exam, isn't it? They should know all of these things, right? But anyway, so genuinely they don't know, right? And in Malaysia, our students, I told you, 18, 19, 20-year-olds, they are panicking. How to do the exam? How are we going to do this? Because in their mind, they've all got it sorted out. We don't have to really study. We just bring all the notes into the exam and we just copy. Which is a terrible way to do it. But the university has said, yes, open book. But now that it's in a hall, the mind just goes crazy. Are we going to have big enough tables where we can put all our notes? One student came and asked me this, and I didn't even think about this. If there are 150 students in a hall, and every one of them is typing, isn't that going to be very loud? I said, you're right. I didn't even think of that, right? So look, isn't that going to be very loud? And so it's going to disturb me from writing. So if you guys are frustrated, all our students in KL also are frustrated. They're all very upset. But yeah, I mean, we got to move on. So ask the university, if Speed is not giving you any answers, please let me reassure you that Speed also doesn't know, right? Because we at ATC also, we don't know, right? So if you're asking Speed and Speed is saying we don't know, genuinely they don't know, right? But I know it's not a great answer, but genuinely they don't know, right? We are constantly trying to get answers, and as soon as we get it, we will pass it on to you, okay? Okay, so coming back to the answer, I can't even remember why I started on that story. Anyway, so these are the two issues, right? Can Ralph continue using the track running across Dan's land, and can he continue using the shed? And Dan, can he continue using the path, right? So firstly, let's look at this. Are they capable of being easements? Re-Ellen Burrow. Firstly, is there a dominant land and is there a servient land? The answer is yes, there is. But, ladies and gentlemen, you must make it clear to the examiner that the dominant land and the servient land varies depending on who's making the claim, isn't it? Right? So, for the right to use the cottage garden, the one that Dan is claiming, the dominant tenement is the rest of the estate. The servient tenement is the cottage and the garden. But for Ralph's rights, for the rights that Ralph is claiming, The dominant tenement is the cottage and the garden. The servient tenement is the rest of the land. Right? The rest of the land, right, is the servient tenement. Are we good? That's it. That's all you need to write. Right? Now, if you wanted to, maybe if you feel that one more line is necessary, the reason why you picked that to be dominant and that to be servient, you can explain. Maybe if you wanted to add one more line, the servient tenement is always the land on which the right is exercised. The dominant tenement is the land that is benefiting. Okay? Now, this is where I told you a very, very common mistake. Please, please do not make it. How many times I've seen the answer? For the cottage, the dominant tenement is Ralph and the servient tenement is Dan. And then for the other one, the dominant tenement is Dan and the servient tenement is Ralph. Cannot, Tenement is land, not the person. Okay? Next, there must be diversity of ownership or occupation, right? So I told you, the time to see this is the time of dispute. So yes, in the beginning, Dan owned all of the land, but that doesn't matter. The time to determine this is at the time of dispute. And at the time of dispute, Dan not just is leasing the cottage and the garden, he also owns the cottage and the garden already. So there is diversity of ownership and occupation. I told you the first two, very quick, very easy, move on. Right? Now, some of you, and this is a fair comment, some of you might say, wow, so many subheadings. It kind of defeats the purpose of subheadings. I agree with you. My writing here is more for teaching purposes. So you may not need this subheading and this subheading and this subheading. You can just write it out as paragraphs. Right? So again, it's a matter of style. Okay? Because there was one year, a few years ago, where you had a word count. I don't know if any of you took exams then. No, none of you would have. This was about 3 years ago. You had a maximum of 5,000 words for the entire paper. So you got 4 answers, maximum 5,000 words. That means each answer you got roughly 1,250 or something like that. So subheadings and all will take up words, then you had to take it out. But nowadays you don't have a maximum word count anymore, right? Which is good. Okay, then the alleged easement must accommodate the dominant tenement. Okay, so this simply means that the right must benefit the dominant tenement and not merely the person that owns or occupies the dominant tenement, right? So what do you think? The alleged easement is the right of way and a right to storage. A right of way and a right to storage. Now, ladies and gentlemen, if you look at my answer here, I have gone with that this is an economic benefit. And I have discussed the London and Blenheim test. Right? Now, for this question, right, I also think you don't have to do it as economic benefit. You can go both ways. You don't have to do it as economic benefit. The right of way through the garden, the right for the track and the storage, right? You could just argue that it is directly benefiting the land as well. If you argue that it directly benefits the land, how would it directly benefit the land? So, wouldn't it be good for the cottage and the garden to have a pathway to go to the main road? It benefits the land. If not, means the value of the land becomes less if there's no direct pathway to the main road. Wouldn't it add value to the rest of the land if they have a track to go because it's the fastest way to get to the train station? Right? It adds value. And wouldn't it be great for the cottage and the garden to have a place to store your quad bike? Right? So, ladies and gentlemen, what I'm trying to say is, if you didn't want to use the whole commercial benefit argument for this question, I think that would have been fine as well. Right? But what I have done is I have argued that it is a benefit. You see, so this is how I've done. Right? In the case of London and Blenheim Estates and Ladbroke, it was stated that what should be looked at is not whether a commercial use or a purely personal benefit is being facilitated by the easement, but whether the alleged easement is so connected with the land that the benefit accrues to the current owner because he owns the estate in the land. So ask yourself for all three of the rights. So let's take Dan, for example. If Dan was not the owner of the entire estate, he was not staying on that land, does he need to walk across the cottage garden to get to the track? No, isn't it? It doesn't make sense. If he's not the owner, he's staying somewhere else, that it doesn't benefit him. It only benefits him because he owns the estate in the cottage garden. The same thing is for Ralph as well. If Ralph was not the owner of the cottage and the garden, does it benefit him to park his quad bike in the shed? If Ralph was staying somewhere else far away, does it make sense for him to come here to park his quad bike in the shed? No. It only benefits Ralph because he owns the estate in the land. So, ladies and gentlemen, even if you apply, if you apply the London and Blenheim test, all of these will be considered to be benefiting the dominant tenement, even though they may seem to be benefiting the dominant tenement owner only. But using the London and Blenheim test, it will be considered to be benefiting the land as well. Okay? And so, yeah, it satisfies. Are there any other issues when it comes to accommodating the dominant tenement? If you remember our lecture notes, there were a few other issues. Proximity. Anywhere here, is the dominant land and the servient land very far away from each other? No. If it's not, don't even talk about it. It's not an issue. Is any one of these a right to recreation? No, it's not. Remember, what is recreation? Play, sports, that kind of a thing. This is not a right to recreation. Any one of it is not. So the only thing here was this. Does it benefit the dominant tenement? So satisfied. Then the last requirement. The alleged easement must be capable of forming the subject matter of the grant. The alleged easement must be capable of forming the subject matter of the grant, right? So remember, there are some very quick and very fast things that you can sort out straight away. There must be a capable grantor, capable grantee, and the right must be certain, sufficiently certain. Now, in your answer, you don't do this. Huh? On the facts, they are all satisfied, right? These are the kinds of things that the examiner hates. Tell the examiner why they are satisfied. So, who is the capable grantor? To be a capable grantor, what do you need? You need to own the land. Right now, you own the fee simple or have a lease in the land. Then you are a capable grantor. Capable grantee is what? You need to own or have a lease in the other land. Here, Ralph and Dan both satisfied. Explain. Right? Are the rights sufficiently certain? None of them are very vague rights. Huh? I don't see any of vague rights here. So it's not a general right to walk. No, it's a very specific. It's a right to walk across the cottage garden to get to the track. You know, everything. The right to park the quad bike in the shed. Very specific. So fine. All that is satisfied. Okay. Now, ladies and gentlemen, this one, this is important. Huh? This is your homework for today. Huh? You see, as part of your answer, you need to go and also say that all the easements that we have in the question are easements that are capable of being easements. So that's our discussion here, right? They are capable of being easements. Now, what you can do to help that is, if it is an easement to park, it's an easement of a right of way. Just give an example of a previous easement of parking that has been accepted as an easement. A previous easement of a right of way that has been accepted as an easement. So, you go home today, and as homework, the usual easements that usually come out in the exam. Find one case each and keep it. Now, don't get me wrong. You are not saying, oh, because in Newman and Jones it was allowed, here it must be allowed. That's not what you're saying. You are saying the right to park has been recognized as an easement. Okay, the right to park has been recognized as capable of being an easement in Newman and Jones. That's all you're saying. So you don't have to reinvent the wheel. You don't have to convince the judge here that the right to park can be an easement. That's already done. Give a case. So what are the usual easements? The right to park, the right of way, the right to storage. So the right of way, Bowman against Griffith. Right away, Bowman against Griffith. Now, again, that's not the only case, obviously, but it's the only case that I can remember. Right? So you pick a case, right? The right of way, the right to park, the right to storage. Storage, you can say right against Macadam. It's in the notes, right? Advertising, you can use Moody against Steggles. The pub case, remember? Right? Underground piping, Donovan against Rana, R-A-N-A. Donovan against Rana, R-A-N-A. What else? What else are the common ones? Parking. Oh, there, Newman against Jones. Okay. So these are the common ones, right? Remember a case for the common ones. By the way, by the time you reach the exam, you would have done 3 or 4 of these questions. You will see what I mean, the common ones. Again, I reiterate, by you bringing the case, you are not saying just because there it was allowed, here it must be. That's not what you're saying. You are just saying that this type of easement, the right to park, the right to store, the underground piping, advertising, these are easements that have been recognized as capable of being easements. That's all you're saying. Okay? So done. But then now we go back to this particular easement. Are there any issues with the 3 easements that you see? Right? So just that, like was pointed out just now, honestly, the only issue is the degree of use issue when it comes to the shed. So let's talk about that. So how would you go about it? We are not told how big the shed is, and we are not told how big the quad bike is. So we don't know. We genuinely don't know how much of the shed is being taken up. So you cannot come to a firm conclusion because you don't know. So all you have to say is, look, if Ralph's use of the shed leaves Dan without reasonable use of the shed, that's the key word that you want to use. Although I didn't use it here. If it is excessive, yeah, reasonable use is nice to use, but you don't have to, right? Excessive, it means the same thing. If Ralph's use of the shed is so excessive to the point where Dan doesn't have reasonable use of the shed, it cannot be an easement. Ladies and gentlemen, you cannot conclude on this because you don't know. You just have to discuss. Okay? And I use the case of Bachelor against Marlowe because it's a parking case. And in Bachelor against Marlowe, it was not allowed. The easement was not allowed because it was excessive use. So assuming that it is not excessive, then we can argue the rights are capable of being easements. Ladies and gentlemen, this is what I mean by easements can be tedious a bit. We've done quite a bit. We've discussed quite a lot, right? We are halfway through the answer only. Right? We are halfway through the answer. Okay, now, second half, acquisition. So let's start with Dan. So Dan, we're going to say reservation, right? Everybody agrees? Anyone disagrees with me when it comes to Dan? No, Dan is reservation. Okay, good. right? And explain why, right? He was the previous owner of the cottage and the garden, and now he is seeking to exercise a right over the cottage and the garden. That has to be reservation lah. So there are two ways of implying an easement by way of reservation: necessity and common intention. Can this be necessity? Immediately no. Why? In fact, I think the examiner also didn't make it difficult for you. Huh? He said it's the fastest way, which means that there are other ways. It cannot be an easement. Now, if you remember, when we discussed necessity, we discussed the case of Wong against Beaumont and Manjang against Drame and MRA Engineering. But this is a reservation situation. So it'll be great if, because it's a reservation situation, you put the reservation case, which is re dot. It's in your notes, re dot. If it's a grant situation where you're discussing necessity, then you bring in your MRA and your Manjang and all of that. But since this is reservation, the case to discuss is dot. Okay. Now, is there common intention, or do you think? Okay. So what is common intention again? You know what must happen for common intention? Either there was actually an agreement between Dan and Ralph. On the facts, don't have. Or any reasonable person that is looking at that arrangement will say, surely Ralph knows that Dan needs to use the path to go to the track. Surely it is obvious that Dan needs to use the cottage garden to go to the track. Is that the case? And I think the answer is no, it's not. Number one, there's no agreement between Ralph and Dan. But number two, the examiner also says that it's the fastest way, right? It's not the only way. So there will be other ways for Dan to get to the train station. You see what I mean? So this is not going to be a common intention also. Right? It's not going to be a common intention situation. So please tell Dan he is not going to get his easement. Right? I've said this before. Don't feel pressured to always argue that the person that you're advising must get what he wants. I mean, obviously, you push. Obviously, you argue to the best of the law's capability. But what I mean is, don't feel that, oh, I cannot say he will lose. That means I am a bad lawyer. No, that's not what is going on here, right? So don't feel that pressure, okay? Ralph. Okay, let's talk about the narrow strip of land first. Let's talk about the narrow strip of land. What did we say earlier? The narrow strip of land is probably going to be Weldon. Right? Now, all this, there are 4 methods of implying a grant, all of that. You don't have to put in your answer, right? You don't have to put in your answer because you are not writing out notes. You are answering the question, okay? So, I have a very quick discussion on necessity. Only because the examiner said it is the only way to the main road. So I have a quick discussion on necessity. But even in my discussion, I make it very clear, it will only work if it is the only way out of the cottage. If it's just the only way to the main road, but there are other ways that Ralph can get out of the cottage, it will not be necessity. Are we okay? Right? So remember, very high standard for necessity. MRA Engineering, Manjang against Drame. Right? So necessity will only work if that track is the only way for him to get out of the cottage and the cottage garden. That was not said by the examiner. Okay? So have a little bit of a discussion and you say maybe can, maybe, but we don't know. So I've said here, the facts are not very clear. The facts are not very clear. Okay, so even if it's not necessity, if it is necessity, very good. But remember, the necessity discussion is maybe, maybe not. So we'll try Weldon against Burrows. Right? We'll try Weldon against Burrows. Why? Just explain the rule. Put the rule down. The rule states that where a person transfers part of his land, which is the dominant land, right? He transfers part of his land to another. That transfer impliedly includes the grant of all rights in the nature of easements that the seller used prior to the transfer for the benefit of the part transferred. Now, you might be looking for the phrase quasi-easements, right? Yeah, I didn't use quasi-easements here, but what that means is rights in the nature of easements. That's quasi-easement, right? You want to use quasi-easement, you can, huh? It's not wrong, right? But there are different ways of saying the same thing, right? So this is the quasi-easement. So again, what is Weldon and Burrows? When the seller sells the dominant land, all quasi-easements that he was exercising prior to the sale will now become a full easement in favor of the buyer. That's the simplest way of putting it. I say it again. When the seller sells the dominant part of the land, all quasi-easements that he, the seller, was using prior to the sale will now become full easements in favor of the buyer. That's it. Right? So on the facts, you must explain. Dan regularly walks from his estate through the cottage garden to reach the track. So we say this would be a quasi-easement, right? And how do I know he regularly walks? Well, my conclusion is because it was the fastest way to the train station, right? When Dan leased the cottage and garden out to Ralph, the rule in Weldon would have converted the quasi-easement into full easements in favor of Ralph. Right? Now, look, I know full easements, some of you might argue that's redundant. Because there's no quarter easement and half easement, right? An easement is an easement. So yeah, if you don't like to use the word full easement, don't use, right? I use it sometimes to teach the students, right? And not everyone I teach back in Malaysia has English, I mean, the English levels vary, right? So when I say full easements as opposed to quasi-easements, it helps. But I understand, full easement is redundant. There's no half easement, there's no quarter easement. So when you say easement, it just means full easement, right? Anyway, so where were we? Yeah, so the rule in Weldon would have converted the quasi-easement into an easement in favor of Ralph. But there are some provisos. There are some conditions that must be satisfied. What are the conditions? Number one, the right must be continuous and apparent, right? The right must be continuous and apparent. So again, what are we talking about now? Sometimes when we get into the details, we can forget what we are talking about. We are talking about the track, the little track on the narrow strip of land. Is it continuous? Did Dan continuously use it? Again, we are going to argue yes. Why? It was the fastest way to the train station. And there's no other indication otherwise. If the examiner said something like, it's the fastest way to the train station, but somewhere later in the question, Dan was a car enthusiast and always drove everywhere he went. That would be an issue to raise. You see what I mean? So sometimes the examiner can throw in a few things to make the question interesting, but here don't have. Okay? So you can argue that it was continuous. And was it apparent? Yes, it's not done in hiding, right? So it is continuous and apparent, and then and necessary for the reasonable enjoyment of the land, right? Is it necessary for the reasonable enjoyment of the land or not? The question to ask yourself, is that track, does it make Dan's life easier? Yes, not Dan, Ralph. That track, does it make Ralph's life easier? Yes. Does it make Dan's life easier? Yes. Because it was a shortcut to the main road. Of course it is, right? It's necessary for the reasonable enjoyment of the land. That's it. So both are satisfied, right? continuous and apparent, and necessary for the reasonable enjoyment of the land. Both need to be satisfied. Case Wood against Waddington, 2015. Wood against Waddington, 2015. Now, of course, the case is not here. I'll be honest with you. I'll tell you why. Because when I wrote this answer, there was no Wood against Waddington. Right? But you add on the case of Wood against Waddington here. But that case doesn't say, it's not a dramatic case. All it says is, it must be continuous and apparent and necessary for the reasonable enjoyment of the land. Right? And necessary for the reasonable enjoyment of the land. Okay, yes, and also it must have been used by the transferor. It must have been used by Dan prior to the sale. So, if all of those things are satisfied, then, notice I said this, unless the lease agreement expressly excludes Weldon against Burrows, it's important to put that somewhere because it can be expressly excluded. So, unless there is some kind of express exclusion, the rule in Weldon and Burrows will apply, and Ralph will be able to argue an implied easement in his favor. Very good. What type of easement does he have? Is it a legal easement or an equitable easement? Well, it depends on the lease. We don't know, isn't it? It depends on the lease. Now, on these facts, ladies and gentlemen, there is a lease and then there is a sale. Correct? Ralph first leased the cottage and garden, and then a few years later, he bought it. For Weldon and Burrows, which transaction are we using? It has to be the lease, right? I hope you see why it has to be the lease. It's not even a question. It cannot be the sale. Because for Weldon and Burrows to apply, prior to the transaction, it must be owned and occupied by the same person, right? So only prior to the lease, Dan was owning and occupying both pieces of land. Prior to the sale, there was diversity of ownership. It cannot be Weldon already. Right? So, it's the lease that counts. So, the nature of the lease will determine the nature of the easement. If the lease was done using the proper formalities, the implied easement here will be a legal easement. If the lease was not done using the proper formalities, the implied easement will be a equitable easement. Everybody understand that? Okay, good. Last one. The quad bike. The quad bike is going to be 62. But let's start the story first. So firstly, when Dan told Ralph that he could park there, it was merely a license. Right? It was merely a license. Why? Because there was no documentation. In fact, the word was allowed, isn't it? Right? So it was just merely a license, right? Then, when the lease expired, Ralph bought the freehold from Dan. So this may trigger the application of Section 62. Okay, so how? The case of Hare versus Gilman and Inskip. If you are using 62 in this way, when I say this way, it means what? Converting a license into an easement, you must read it together with Hare versus Gilman and Inskip. Because 62 alone does not say that. So you cannot say, look at 62, this is the effect of 62. No, it's 62 will apply because of how it is interpreted by Hare versus Gilman and Inskip and Goldberg against Edwards. Right? Remember, I gave you two cases. You don't have to use both, but I'm just giving you two cases, right? In the notes. So the case of Hare versus Gilman and Inskip states that if 62 applies, it will convert licenses that were previously enjoyed on the land into easements for the benefit of the purchaser. So here, who's the purchaser? Ralph. So we are trying to argue that the sale, not the lease, the sale will convert the license into a full easement in favor of Ralph. Okay. What are the preconditions for 62? Number one, it must be a conveyance. What is the definition of a conveyance? That means the proper formalities must have been complied with, which means it must be done by deed and there must be registration, right? Even for the sale. Huh? The proper formalities must be complied with. That's a conveyance, for one. Number two, what is the second requirement? There must be prior diversity of occupation, right? There must be prior diversity of occupation between the dominant land and servient land. Prior to what? Prior to the sale. So, prior to the sale, was there different people occupying the dominant land and servient land? The answer is yes. Prior to the sale, Ralph was already staying in the cottage and cottage garden, and Dan was already staying in the rest of the land, correct? So there, satisfied. So, number one, conveyance. Number two, prior diversity. Both of this satisfied, then tell the examiner 62 will apply unless it has been expressly excluded. Again, don't forget that line. Unless it has been expressly excluded, 62 will apply and Ralph will get a easement, implied easement to park his quad bike in the shed. What type of easement will Ralph get? Legal. Is there any other option for 62? No. Do you see why or not? See, for 62 to apply, the sale or the lease must be a conveyance, correct or not? And I told you the nature of the easement will follow the nature of the document. So for 62, that document must be legal. So that every time you use 62 successfully, the easement that you will get will be legal. Always, always. There's no other way. Right? Every time you use 62, you will get a legal easement. Are we okay? All good? Let's look at another question. We'll take a break now, right? We take a break. We come back and we will look at another question. Let's look at the other 2012 question. This one. Okay. We will go through this a bit faster and then we can go home. Okay, but now is a break. Huh? Let's take a short break, 10 minutes. So if it's a monetary benefit, it's okay. Okay. Now, secondly, it's okay if it's a monetary benefit. It's just that the monetary benefit, the economic benefit, must be accruing to the claimant. So in this case, it is, who's asking? Oliver, right? It must be coming to Oliver because he owns the estate in the dominant land. Because he owns the estate in the dominant land. So the dominant land here is Brownland, right? Yes, he is making money, but is it because he owns the estate there? So how do we test this? So imagine. So yesterday I got a question. So if we remove him from the land, then what is his status anymore? So I want to reiterate, the removal from the land is not real. You're just, it's just a test, right? If you remove him from Brownland, that means he doesn't own Brownland anymore. Will he still need that pathway across Green Acre? No, isn't it? He is bringing his cows across Green Acre. Look at the picture. He's bringing across his cows across Green Acre to Brownland because the milking parlor is in Brownland. If he wasn't the owner of Brownland, that pathway across the track across Green Acre does not make sense to him, right? So it makes sense to him. It is an economic benefit to him because he owns Brownlands, correct? In that case, this can be an easement. Okay? So remember, this is a test only when it's an economic benefit. I am arguing that the track is economic benefit. The other two, I don't know. Do you think the other two are economic benefits? The underground piping, maybe you can argue that also as economic benefit. But I didn't, right? I say the water pipe there is, it benefits the land. Can you imagine a land where 3 months in a year you got no water? That's going to be terrible for the land, right? So the underground piping adds value to the land directly. It's not an economic benefit. But again, guys, I want to reiterate this. Just say in the exam, you are thinking, Daniel said this was economic benefit, but I thought it was not. Don't worry about it. If you think it was not, then you discuss it. Show how it benefits the land. Right? But if it's an economic benefit, then you argue London and Blenheim estates. Right? So it just all depends on how you interpret the question and you argue it. Right? So I am arguing the water pipe and the barn, they are not directly economic benefit. I can argue they directly benefit the land. Okay? So again, what do I mean by directly benefit the land? There you see. Both of these rights definitely enhance the value of Green Acre now because the owner and occupier of Green Acre will have a place to park large farming vehicles and will have a steady supply of water. Right? So that benefits the land, right? Because remember, once it's an easement, it doesn't only benefit Oliver, no. When Oliver sells the land, the new person gets the easement. When the new person sells the land, the next person gets the easement. So that's why we are saying it benefits the land. Okay? So that is the accommodating the dominant tenement. Any other issues here? Again, there's no proximity issue. Both lands are side by side. This is not a recreation issue, right? Yeah, so no issues. Moving on. The alleged easement must be capable of forming the subject matter of the land. So capable grantor, capable grantee, sufficiently certain. Do we have all of that? We do. Right? Remember, a capable grantor is just a person who is granting the easement, or you want them to be granting the easement. They must own the land, or they must own a lease in the land. On the other person who is receiving the easement, they must own the land, the other land, or they must own the lease in the land. That's a capable grantor and a capable grantee. Right? None of these rights are vague rights. Remember, what are vague rights? the right to a view, a right to play, a right to have fun. These are all vague rights. These rights on our facts are all quite certain. Okay? And then show the examiner that all of these rights are rights that are capable of forming, being an easement. So the right of way is which one? The track across Greenacre, right? This is a right of way. The right of way, the case that where this has been accepted before is Borman against Griffith. The right to park, which one is the right to park? The combined harvester in the barn, right? Newman against Jones. So again, I know I'm repeating myself. You don't like Newman against Jones, you go with the Nissan Motors case, where the right to park was allowed. So many cases, okay? And then underground piping, Donovan against Rana. Whenever it's underground piping, it's Donovan against Rana. Remember, I told you, keep a few cases. Keep one case for every one of the common rights. So these are 3 already. Apart from this, my advice to you would be advertising signage. Is quite common also. Advertising signage, that is Moody against Steggles. And then storage. Storage, right against McAdam. I think these 5, you should be good to go, Adila. Right? Okay, anyway, now, so those are the preliminary stuff. Now, any one of the issues that can arise here. So very similar to the previous question. Very similar to the previous question is going to be the degree of use issue. The degree of use issue here is the combined harvester. When they park it in the barn, does it leave Oliver? Does it leave Oliver with reasonable use of the barn? That's the question here. Does it still leave Oliver with reasonable use of the barn? Look, we don't know. Once again, same answer. We don't know how big the combined harvester is. We don't know how big the barn is. So, if by, what's his name? Ed. I can't remember his name. E. If by E, parking the combined harvester in the barn, if it leaves Oliver without reasonable use of the barn, this cannot be an easement. However, we will proceed on the assumption that it does. That's it, right? And since it is parking, we'll talk about Bachelor against Marlowe, Nissan Motors, right? The Nissan Motors case, R Square Properties against Nissan Motors, all of this, right? So the final conclusion is here. We are not told how big the combined harvester is, how large the barn was. We don't know. So we will proceed on the assumption that it's okay. At this point, we are good. All 3 easements are capable of being, I should say all 3 rights are capable of being easements. Anything we missed, you think? Right? If you think anything we missed, you can let me know tomorrow as well. Okay, then. The acquisition part. Acquisition, do it right by right. Or person by person, however you want to do it. Here, I'm doing it right by right. The right of way. The right of way here is this one, the pathway. So that's going to be reservation. So reservation, it's going to be 2 ways only. Necessity, common intention. Do you think it's necessity? If there was no other way to leave Brownland except for the path, that means the only way this is going to be necessity is if there was no other way to get out of Brownland. Because if the issue was there was no other way to bring your cows to Brownland, that is not enough, The court will say, don't use that land for cows anymore. The standard is very, very high. It must be there was no other way to leave Brownland. Then it will be necessity. Because the test is, ladies and gentlemen, without that easement, the land becomes useless. Not without the easement, the land becomes useless for milking cows. That's not enough. It must be useless, full stop. It's that high a standard. Okay? So, look, we don't know, right? If there was no other means to leave brownland except for the path, then maybe it can be implied by way of necessity, right? Here I put another case. This is the same along the lines of your MRA engineering, except MRA engineering and Manjang was where it was not allowed. Pennington is a case where it was allowed. Okay? However, if this was not the case, then Oliver may still rely on common intention. Now, the issue here is this. Two things. Number one, did Oliver and Ed have some kind of agreement that Oliver will still use the path? Or was there, did Oliver know, did they talk about it, that Oliver will still be using brownland for milking? If Ed knew that Oliver was still going to use brownland for milking, and when he bought the land, he knew that Oliver was still going to use brownland for milking, then, ladies and gentlemen, it can be an easement by way of common intention. Other than that, cannot. The case of Chaff against Kingsley. Remember that case? It's not here, but it's in your notes. Use it. The case of Chaff against Kingsley. The courts held that the courts are not going to be so, it's not going to be easy to establish common intention, especially by way of reservation. So you must have the relevant evidence, right? It's not going to be easy to establish common intention by way of reservation. Why? Because if you think about it, Oliver here was in absolute control, isn't it? When Oliver sold the land to Ed, he is the one selling. He was the one with the, if you like, the power. Or at the very least, they were at equal power. He could have inserted it into the sale and purchase agreement. If you choose not to, then it's your problem, no? So, reservation done for Oliver. Okay? Let's go to Ed. Ed with the water pipe, what did we say earlier? Weldon against Burrows. Why Weldon against Burrows? Because prior to selling it to Ed, when Oliver was owning both Greenacre and Brownland, Oliver also used the water pipe. So that's a quasi-easement. So explain. Same thing. Explain the rule. Find yourself a nice one sentence explaining the rule. Different textbooks will give you different sentences. My notes is mainly, you probably figured this out, structured after Martin Dixon's textbook. So the wording there is a mixture of mine and Martin Dixon's, right? But if you wanted some unique way of explaining the rule in Weldon against Burrows, pick up another textbook, right? I'm sure there are other textbooks that you can borrow from your library here or the online portal, right? Last year, a student told me that you can download textbooks from the online portal. I didn't even know that. So you can. Don't waste that advantage that you all have, right? So anyway, pick one line, explain the rule. After explaining the rule, apply the rule. Right? Apply the rule. Do you think it'll be satisfied? It will. Why? Before the land was leased to Ed, Oliver was the owner of both pieces of land and he was using the water pipe. So this will be a quasi-easement. It means, and then Oliver sold the dominant land. Did he sell the dominant land? He did, right? Because for the water pipe, the dominant land is Greenacre and the servient land is Brownland, correct? So he leased out Greenacre. So upon sale or lease, so in this case lease, upon lease of the dominant land, all quasi-easements, it was a quasi-easement, that was used by the seller or lesser, in this case is the person leasing, that was used by the person leasing will be converted into easements in favor of the buyer or the tenant. And that's exactly what will happen here. Provided two things. Number one, it must be continuous and apparent, right? Continuous and apparent. So is it continuous and apparent? I think that it is continuous, right? So because we were told of the circumstances, right? We were told of the circumstances where it is really needed every 3 months because the river on Green Acre dries up. So definitely it will be continuous. Summer comes every year, right? It's not like summer doesn't come 1 year, and also it's continuous. Is it apparent? I argue it's apparent. And is it necessary for the reasonable enjoyment of the land? Is it necessary for the reasonable enjoyment of the land? The answer is yes. It's always nicer when you got water on the land, correct? So done. Weldon and Burrows will apply, and so Ed will be able to use the pipes by virtue of the rule in Weldon against Burrows. What type of easement does he get? It will depend on the lease. If the lease was legal, the easement is legal. If the lease was equitable, the easement will be equitable. Not too bad, right? Last one before we go home. The barn. So the barn is going to be section 62, right? By virtue of, or as interpreted by the case of Havses, Gilman, and Inskip. As interpreted by the case of Havses, Gilman, and Inskip, right? So what are the preconditions for 62 to apply? Number one, must be a conveyance. We have to assume it's a conveyance. We were not told. Number two, prior diversity of occupation or ownership. So this is prior to which one? The sale or the lease? Sale. Very good. This is prior to the sale, right? Because remember in the notes you see here, one of the preconditions is that license must have been used prior to the triggering transaction. That's another tip why it's not the lease. Because prior to the lease, Ed was not using the barn. Ed was only using the barn prior to the sale. So that is why it's the sale that we are talking about, right? And so if the two preconditions are satisfied, ladies and gentlemen, 62 will apply. And what will happen? Well, again, if it was not ousted expressly, 62 will apply, and the lease will be, the license will be converted into an easement in favor of Ed. Okay, very good. Tomorrow, I want to do this question first. You can take a look at it. The 2016 question, right? Not today, tomorrow, right? This is what I'm going to do. And then what I'm going to do is, depending on how far we get on this question, I've given you a 2017 question also, right? The 2017 question is very easy. We'll finish it quite quickly. So if we have the time, I will project some new questions without an answer, and we will discuss it immediately here. Okay? Maybe I will give you 10 minutes to try and figure it out, and then we will discuss it. Okay? And you should try it. I think that is that's the best way to figure out the law. Okay, ladies and gentlemen, thank you very much. This is where I will stop today, and I will see you all tomorrow at 7 o'clock as well. Thank you.